Hi, my name is Joe Fortunato, and I'm the attorney for the Main Street Organization of Realtors. And I'm here today to talk about when is a contract really a contract? And everybody's going to think, well, why should I be bothered listening to this? Because we all know that we have to have a contract in writing signed by both parties. Isn't that pretty simple? Well, that's one of the first things you learn in pre-licensing course, that in order to have a binding contract for the sale of real estate, there had to be a contract signed by both parties. One of the cornerstones of the law of real estate is called the Statute of Frauds. The law originated in England in the 17th century. And among other things, it determined that in order to have a binding agreement to buy and sell real estate, there had to be some sort of writing that was signed, as they put it, by the party to be charged. In other words, the document didn't have to be signed by the party who asserted that there was a contract or tried to enforce the agreement, as long as it was signed by the party against whom the agreement was to be enforced. The law was based on the belief that real estate is unique and that it wouldn't be fair to try to enforce an alleged agreement against a party who denied that an agreement was in place when there was already some document that contained his signature and then manifested the agreement. We know that normal procedure involves an offer signed by a buyer and then accepted in writing by a seller. We also know that when a seller signs the offer but makes changes to the offer, those changes constitute a counteroffer and must be accepted by the buyer. Additional changes by a buyer in that instance constitute another counteroffer, requiring, in order to form a contract, a mirror image where all terms are finally accepted by both parties. But like almost everything else in the law, there are exceptions. Partial performance, or sometimes called substantial performance, of a real estate contract involves a party providing partial payments, taking possession, making improvements, thereby allowing a court to enforce an oral agreement for the sale and purchase of real estate. Courts would have difficulty in such a case restoring the parties to the condition in which they were prior to the time the alleged oral contract began. These situations arise in the context of installment contracts for deed or lease with option to buy agreements. Another exception is when a party, by word or by action, admits the existence of a contract for the sale and purchase of real estate, even though it's not signed. In such a case, requiring a signature on a document in order to find the existence of an enforceable agreement wouldn't be just, and the law recognizes an exception for admissions. I caution you, though, that admission must be so clear as to leave no doubt that an agreement exists, and you may not ever run into a situation like that. Promissory estoppel is another recognized exception to the statute of frauds and can result in the enforcement of a contract that is not written and signed. Requirements are: a party justifiably relies on the promise of the other party, that reliance causes harm to the person who relied upon it, the party who made the promise could have reasonably foreseen that reliance, and the only way to avoid injustice is to enforce a contract. The situations I've described are somewhat rare and are typically in the context of installment contracts called land contracts or articles of agreement for deed, and some real estate professionals may never have such situations in their real estate practice. Lately, however, another more practical and everyday occurrence has to do with communications by real estate professionals made on behalf of the parties via various forms of electronic media. A real estate professional is subject to the law of agency and has authority to bind a party for whom he and she represents, so long as there is some written authority from the principal to the client. And most listing agreements and buyer brokerage agreements that we run into don't contain language that could be construed as granting such authority. But a problem can arise in the following context. Buyer makes a written offer to purchase real estate for sale. Listing broker responds via text, email, or other medium: my seller will accept X dollars for the property. The buyer accepts the counteroffer proposal and on the price, and the seller doesn't sign anything, doesn't approve the price change in writing, tries to take the property off the market. So what's the problem? Our board-approved marketing agreements do not contain written authority for the listing broker to enter into binding agreements on behalf of the principal. The problem is that the listing broker in that scenario above appears to have authority to bind the principal. If the principal is an institution, a quasi-governmental agency, or a bank, a listing agreement wouldn't be the board-approved marketing agreement. The buyer may in such a case want to investigate to determine whether the principal allowed the listing broker to enter into a binding contract on the principal's behalf. If there is such written authority, the court could easily find that a contract had been formed. In an actual situation, a listing broker representing an institutional client was accused by a disappointed buyer of having written authority to enter into a contract on behalf of the seller who refused to sell and who took the property off the market. The buyer hired an attorney and demanded to see the listing agreement to determine whether it contained such authority. Eventually, the matter was resolved, but not before the listing brokerage incurred substantial attorney's fees and expended time to vindicate itself. The listing broker, or any real estate professional for that matter, in this situation should provide a disclaimer to avoid the situation arising. And the disclaimers could be such as, the broker has no written authority from the client to enter into a contract on client's behalf. Or, the above message constitutes negotiations that are not to be considered binding upon my client unless and until my client approves all terms in writing. So you get the idea. A small amount of effort during negotiations using these typical methods of electronic media may prevent the expenditure of time and expense down the road and avoid claims by disappointed buyers as well as an equally disappointed client. Thank you for your attention.